After a gunman in Las Vegas killed 60 people at a concert in 2017, officials focused on a gun accessory known as a bump stock, a device that allows a rifle to fire at nearly the rate of a machine gun. Bump stocks were banned by the Trump administration after that mass shooting. But when the Supreme Court last week struck down that ban, which had been a rare victory for gun safety advocates in recent years, it had the potential to open the door not just to bump stocks. The ruling could also undercut President Biden's efforts to restrict other gun accessories that give semi-automatic rifles rapid-fire capabilities, lawyers and gun policy experts on both sides of the gun debate said. The devices are replacement triggers, known as forced reset triggers or wide-open triggers, that allow shooters to fire more than 900 rounds in a minute with one continuous squeeze, federal officials say. In March 2022, for years after the ban on bump stocks was issued, the Bureau of Alcohol, Tobacco, Firearms and Explosives also imposed restrictions on some of these trigger devices. The agency said in a letter at the time that the devices effectively turned semi-automatic weapons into prohibited machine guns. But now, lawyers and experts said that those restrictions could be appended by the Supreme Court's 6-3 ruling overturning the ban on bump stocks. Immediately after the court issued its ruling on Friday, lawyers for gun rights groups suing to overturn the trigger restrictions filed a letter citing the bump stock decision as a new authority that weighs directly on a central question in this case. That question is, what defines a machine gun? Machine guns are largely illegal and have long been tightly restricted under federal gun laws stretching back to the 1930s. The federal government has argued that accessories like bump stocks and forced reset triggers essentially convert semi-automatic rifles into fully automatic ones. Bump stocks allow a rifle to rapidly slide back and forth as it fires, harnessing the gun's recoil to create a fast burst of shots. Forced reset triggers work by quickly snapping a rifle's trigger forward after it is pulled. The devices are among a niche group of modifications that allow guns to shoot faster, sometimes with deadly results. The gunman in the Las Vegas concert attack, the deadliest mass shooting in modern U.S. history, had 14 rifles outfitted with bump stocks. The shooter, who killed 19 children and 2 teachers at a school in Uvalde, Texas, in 2022, had a Hellfire trigger device, though he did not appear to have used it. The end result is similar, said David Puccino, legal director of the Giffords Law Center, a gun violence prevention group. From the perspective of the shooter, it's automatic fire. But Justice Clarence Thomas, writing for the court's conservative majority, said that a semi-automatic rifle equipped with a bump stock is not a machine gun because it cannot fire more than one shot by a single function of the trigger. Gun rights groups and sellers of trigger accessories seized on that line, saying that it gave them a clear path to argue that the A.T.F. 2022 decision on forced reset triggers should also be struck down. They argue that the mechanism of a forced reset trigger differentiates it from a true machine gun, both practically and in the eyes of the law. The A.T.F. declined to comment, citing pending litigation. This is one of the key legal arguments we've been making from day one, Lawrence DeMonico, the president of Rare Breed Triggers, a manufacturer of the devices, said in a video message to supporters. It is an amazing ruling. Editor's picks I love you, but I don't want to sleep with you. 5 places to visit for Pride in New York Oxtail is gaining fans. Not everyone is happy about that. He added that the court's decision would have a direct impact on our efforts to end the A.T.F.'s illegal attack on forced reset triggers. Gun Control Group said that the Supreme Court's opinion in the case, Garland v. Coghill, was unlikely to give any legal cover to one illegal subset of these devices, known as switches. Switches convert semi-automatic handguns into automatic weapons and have been blamed by police officials for making guns deadlier and putting bystanders at greater risk of getting hit in a spray of bullets. Federal agents have sought to crack down on what they call illegal machine gun conversions using forced reset triggers. Prosecutors criminally charged one man in Puerto Rico and another in Texas for illegally possessing trigger modifications. Some gun owners have surrendered their trigger devices to A.T.F. agents rather than risk prosecution, according to court records. Despite the restrictions, similar trigger devices are still available online for $300. In YouTube videos, gun owners demonstrate how to install forced reset triggers and fire dozens of bullets in a few seconds. Gun rights supporters say the devices are constitutionally protected gun modifications. The federal government has also gone after Rare Breed Triggers, a company operating out of Texas that assured customers that the devices were absolutely legal, according to court papers. The company drew federal scrutiny soon after it started selling force-reset triggers in December 2020 and sold 100,000 of the devices over 2 years, according to court records. In July 2021, the A.T.F. sent the company a letter telling it to stop selling the devices, according to court records. The federal government sued the company in New York, saying that Rare Breed had broken federal gun laws and had withheld information from the A.T.F. In August 2022, A.T.F. agents showed up at the home of a Rare Breed customer, Patrick Carey, near Baton Rouge, with a letter warning him that he might be breaking federal law because he owned guns outfitted with forced reset triggers, according to court papers. He surrendered 2 of the triggers to the agents. "I did not want to get rid of my forced reset triggers," he wrote in a declaration filed in court. A handful of owners of forced reset triggers decided to fight, and in August 2023 they joined with the National Association for Gun Rights and sued in federal court in Texas. They argued that the A.T.F. had overstepped its authority. The 2 court cases yielded split results. A Democratic-appointed judge in the New York case sided with the government and ordered Rare Breed to stop selling the prohibited triggers. But in Texas, a Republican-appointed judge sided with gun groups and partially blocked the government from enforcing the trigger restrictions. The groups now suing the Biden administration over the trigger restrictions said they felt as if their position had strengthened since the Supreme Court issued its bump stock decision. Gun control groups said that they were worried that the Supreme Court had opened the door for more gun modifications that will allow rapid-fire rifles to proliferate nationally. "Assault weapons are dangerous already," Nick Saplina, the senior vice president for law and policy at Everytown for Gun Safety, said in an email. "The modifications," he said, "make this deadly problem even worse." A Nashville judge said on Monday that she would soon rule on whether writings left by the assailant who killed 6 people at a private Christian school last year could be released. The judge, Chancellor Aisha L. Miles of the Chancery Court in Davidson County, has been asked to weigh demands to release the writings as vital public records against the wishes of families at the school who say they want to protect their children from further trauma. Here's what to know about the case. What do we know about the writings under dispute? The assailant who killed 3 third-grade students and 3 staff members at the Covenant School in March 2023 left behind more than a dozen folders and journals in a car and at home, according to a search warrant. Together, they amount to hundreds of handwritten pages, officials said, some of which reflect a hateful plan to target the school. But beyond saying publicly that the shooter considered the actions of other mass murderers and was under treatment for an emotional disorder, the police have yet to outline a motive for what was Tennessee's deadliest school shooting. The records are currently with the Metropolitan Nashville Police Department, which denied all requests to release them while investigating the attack. In response, journalists, gun rights groups, and a Republican state senator sued for their release last year. Excerpts and details from the writings have twice been leaked and published, including this month by the Tennessee Star, a conservative news outlet that is also suing for the full release of the records. City and police officials have said that the leaked material is only a fraction of the writings left behind. What are the arguments for and against releasing the writings? The case has significant implications for journalists and public records in Tennessee. It comes at a moment when multiple states in the region have moved to limit access to the paper trail around governors and top agencies or unmask the sources behind damaging leaks. This fight over the Covenant records has become so pitched that it could have an effect on routine access to police records and the transparency of law enforcement, said Deborah Fisher, the executive director of the Tennessee Coalition for Open Government. Chancellor Miles must now consider the protections of open records law, the public's right to know, and the First Amendment, against concerns from the Covenant community and outside experts about inspiring other mass shootings. Editors picks a mysterious monolith appears near Las Vegas. Why? It's anyone's guess. Looking for friends? How about 23 housemates? The history of Juneteenth, but in instances where a shooter's writings are not immediately disseminated online, courts have moved to release some records, nearly 1,000 pages of documents related to the Columbine shooting in Colorado were released in 2006 because of a court order. And a 5-year court battle in Connecticut allowed the Hartford Courant to view documents from the gunman responsible for the Sandy Hook Elementary School shooting. One possibility in the Covenant case is that the judge will allow the documents to be released, but with some redactions to hide sensitive details. She also may consider an argument that the families of the surviving students now have copyright protection over the writings after the shooter's parents transferred legal ownership of the writings to them. This is not your typical open records case, Chancellor Miles told the lawyers on Monday. Her decision is almost certain to be appealed. Why has it taken this long to decide the case? The case hit a snag early on when nearly all of the families of surviving students, the Covenant School, and the adjoining church argued that they had a right to have a say in the proceedings because they had been harmed in the attack. Lawyers for the journalists and outside groups resisted, and it was not until late November that the Tennessee Court of Appeals ruled in favor of the parents, school, and church. That paved the way for a Today trial in April. Chancellor Miles said on Monday that she had been prepared to release her decision, at least 60 pages in length, last week. But she said she held off after a reporter asked the court about the Tennessee Star articles that had drawn from leaked excerpts. How much of the writings have already been leaked? There have been 2 instances of excerpts from the writings being publicized, as backlash over the delay in releasing the documents has grown. Right-wing activists have accused Nashville officials of intentionally trying to cover up the details behind the shooting after seizing on the assailant's gender identity as a possible factor. The police said the shooter was transgender, but have not said whether gender identity was a factor in the attack. In November, a conservative political commentator published 3 photographs that appeared to be pages written by the shooter. That infuriated the families of the Covenant School students and led to an internal police investigation into the leak, which was ultimately inconclusive. The Tennessee Star then obtained images of documents left in the shooter's car on the day of the attack and published a series of stories quoting portions of the documents. Nashville police and officials have signaled that they plan to investigate who shared the documents with the Star. The news outlet's chief executive and editor-in-chief, Michael Patrick Leahy, was summoned to appear in court on Monday, which he objected to as an infringement on his First Amendment rights. The media does not lose the right to report because they seek access to public records, said Mr. Leahy's lawyer, Daniel Horwitz. Laura Fox, a lawyer for the Nashville government, estimated that as of the Monday morning hearing, content from at least 2 pages of the journals had been released. The amount of materials is certainly not the whole case at this point, and there are quotes taken that are not complete, she said.